I'm going to put out a bench warrant for your arrest.
You practice in front of bench. That's my job or my attorney job. I'm sui juris. I'm propria persona.
Okay, Mr. White, I don't know where you read the stuff that you're saying, but it's legal nonsense.
I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace,
okay, sir.
I'll travel. I travel. I don't drive.
Okay.
I have no contact.
Sir, here's what we're doing, Mr. White.
Today's courtroom scene is a masterclass in judicial patience meeting defiance head-on. Picture this: a no-nonsense judge locking horns with a self-declared sovereign citizen who seems determined to derail the proceedings. From the very start, the individual refuses to stay quiet, constantly interrupting and tossing out legal jargon that doesn't quite fit. But the judge, cool as ever, staying calm, collected, and laser-focused. And when the nonsense keeps coming, the judge finally drops the gavel, figuratively speaking, and shuts it down hard. Watching this moment unfold is oddly satisfying. You can't help but respect how the judge maintains order without losing composure. What do you think? Did the judge handle it right? I'd say he nailed it. Let's dive into how it all unraveled.
The telephone ending in 1336. Tell us your name, please.
I come in sui juris.
Only one of you actually has that phone number, and the other people are just wrong about what their phone number is. Who's calling ending in 1336?
Sui juris and personal persona. I'm Stephen hyphen Tyrell colon White comma beneficiary and sovereign. I'm here under fraud, menace, and arrest. Fiduciary Daniel Williams Norbeck.
Okay, Mr. White, we're going to pop you over in the waiting room because you're just going to be a distraction for all the citizens here willing to abide by the laws of our country. So we'll pop you over in the waiting room and we'll get back to you. In case you guys have ever heard of the term sovereign citizen in the news, that's what one of them sounds like when they try.
Respect where it's due, this judge clearly runs a tight ship. From the moment court is in session, it's clear he's not playing around. In a clever move, he saves the sovereign citizen's case for last, perhaps hoping the extra wait time might cool the man's jets or spark some self-reflection. It's a strategic pause that adds a layer of psychological chess to the courtroom dynamic. Will this delay change the defendant's tune, or will he double down? Let's find out how this gamble plays out.
Mr. White, are you able to hear me?
Your Honor.
All right. I'm going to read this to you so you understand what you're charged with. This says that on January 7th of this year on 2nd Street there in the city of Fenville, that you were driving while license suspended. That is a misdemeanor. It's punishable by up to 93 days in jail and for $500 fines and costs. Do you understand your charge?
Objection, Your Honor. I do not. I do not understand my charges or
okay. I'm going to mark you down as not guilty, and we'll set you for a jury trial. You can continue to.
Your Honor. Your Honor. You practice in front of bench. You practice in front of bench. That's my job or my attorney job. I'm sui juris. I'm propria persona.
Okay, Mr. White, I don't know where you read the stuff that you're saying, but it's legal nonsense. It means nothing in a court of law. So if you're not willing to state that you even understand or recognize the authority of the court, my options are I can make you come in for arraignment and not give you a PR bond, and then you'll have to post bond to not sit in jail. You want to do it that way instead? Right now, if I get through arraignment with you, I'll give you a PR bond. Mr. White?
I'm asking you a question.
What's the question, sir?
I'm not arguing with you, Your Honor. I just want you to hear me. I just want you to hear me.
Okay, but I don't want to listen for 20 minutes. Go ahead and ask your one question, and we'll start there and see if it's a real question.
Am I on the record?
Yes.
It's not going to take 20 minutes, Your Honor. I give you my word.
Well, you said you have a question, sir. What's the question you want to ask?
Is this criminal or is it civil?
This is criminal, sir. It's punishable by up to 93 days in jail and or $500 fines and costs.
Hey, if it's criminal, can I ask to dismiss the...
Now here's where things go from curious to outright baffling. As the hearing picks up, the defendant starts firing off random legal questions, clearly confusing the purpose of the session. He's acting like he's arguing a complex Supreme Court. Case when, in reality, this is just a basic hearing, not even close to a trial. Throwing around legal phrases without understanding their meaning doesn't make you a legal expert. It just creates chaos. It's like watching someone try to freestyle their way through a rule book they've never read. You've got to wonder, should the judge have just pulled the plug and moved on? Or was it worth letting him keep talking and watching the situation unravel even further? Let me know what you'd have done.
At this point, the prosecutor, there's no sworn testimony. There's no sworn.
It's because this is just arraignment, sir. What you're talking about is trial. That would be several steps down the road. Arraignment is just for you to make sure that you understand what you're accused of, what the penalty is, and for you to enter a plea. You're accused of driving while license suspended. I read to you what the possible penalties are, and I asked you if you wish to plead guilty or not guilty at this time.
No, Your Honor, I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace,
Okay, sir. Those sentences don't mean anything. They have no legal meaning whatsoever.
It's guaranteed by my
I've
constitutional
indicated that since you can't understand arraignment, I've entered a plea of not guilty on your behalf. I've set you for a jury trial. You can represent yourself free of charge, or you could hire an attorney. And now you must make a choice, sir, for bond. If we get through the arraignment with you on Zoom, I'm going to give you a PR bond, personal recognizance bond. That means you don't have to post any money. We're essentially trusting you that you'll keep coming back for your court dates. It is no driving without a valid driver's license. If you cannot get that far, in other words, if you really don't understand what's happening here, then I'm not going to allow you to be arraigned by Zoom. I'm going to set you for arraignment in person. And you will come to this courthouse. You will not get a PR bond. You will get a $300 cash or surety bond, meaning that you will need to post $300 in cash, or you will sit in jail from that day until your trial date. So I'll give you a choice. Do you want to be arraigned over Zoom like we're doing today, or would you like to come in and be arraigned in person?
Well, I object to all of this, Your Honor, because at this point, I don't even understand the charges. I do not understand the charges. I'm not trying to.
That's fine. No, sir, you're allowed to, sir. You're allowed to object, and I understand your sentence that you don't understand the charges. And so I will attempt to work with you for that for a second. I'm going to read the charges to you, okay? This says that it takes place on January 7th of this year. You understand that, right? The date that I just read.
I'm saying I do not. At this point, Your Honor, it's I was saying this. It was a jurisdiction matter. It's a jurisdiction matter. That's what I'm saying. It's a subject matter, jurisdiction.
Here's the problem with you arguing jurisdiction. I am a lawyer, so I understand what jurisdiction means. I'm not sure you do.
Let's take a moment to appreciate the judge's mastery here. While the sovereign citizen flounders, grasping at legal straws and talking in circles, the judge stays unshakably composed. No raised voices, no drama, just calm, firm direction, and an unwavering grip on the room. It's honestly refreshing to see a judge who knows exactly when to draw the line without letting emotions steer the wheel. Some judges get flustered or fed up too quickly, while others let disruptive litigants ramble endlessly. This judge, though, he's perfectly balanced. Think of him as the courtroom version of a seasoned coach, disciplined, in control, and focused. On results. Whether you think he's being firm or a little too firm, you can't deny the effectiveness. I think he handled it just right, but I'm curious to hear your take.
The accusation is that you're driving around on 2nd Street in the city of Fenville, meaning in Allegan County, and that you're doing so when your driving privileges with Secretary of State have been suspended or revoked. Because this is the county. Yes?
Objection. I travel. I don't drive.
Okay.
I have no contact.
Sir, here's what we're doing, Mr. White. You are no longer able to be arraigned by Zoom. What I'm going to do is adjourn this. I'm going to adjourn this, and you will get notice at your address there. You will come in, and we will arraign you in person. I'm telling you that I'm not going to give you I'm not going to give you a personal recognizance bond. Sir?
It has to be, before we can
Mr.
proceed,
White.
before you can proceed, it has to be
Mr.
addressed,
White.
Your Honor.
Because we are on the record, I'm going to make this infinitely clear. You're going to get notice to appear in front of me. You have two choices. If you do not appear, I'm going to put out a bench warrant for your arrest. If you do appear, we will have this conversation again about arraigning you to see if you understand the charges, but you are not getting a PR bond. You will need to bring with you $300 cash or surety, or you will be in jail. Do you understand those two options, A and B?
That's a violation of my constitutional rights, Your Honor.
Well, no, it isn't, sir. So we're all set for today. We're done talking. We cannot make any progress. You will be asked to come in person for arraignment. You can either choose to come in for arraignment or you can choose to not be here. If you choose to not be here, a warrant will be entered for your arrest. And if you do choose to be here, make sure you bring that $300 because you're not getting a personal recognizance bond. But we are done with this hearing. I'm going to go ahead and release you. Thank you.
When's my date for court?
And finally, we get to the most frustrating part: refusal to listen. The judge laid everything out crystal clear. Next steps, next date, everything. But the sovereign citizen just stared blankly, seemingly more invested in reciting some memorized script than understanding what was actually happening. It's like he came prepared to perform, not participate. The sad truth is, if he had just listened, this could have been a straightforward matter. Maybe a fine, maybe a class, maybe even a quick resolution. Instead, he's risking jail over theories that hold no legal water. What's wild is that the court often bends over backward to offer simple solutions, and still, these folks manage to complicate everything. If anyone can explain what their actual endgame is, I'd love to know. One thing's for sure: imaginary loopholes don't hold up in court. The law is direct. Show up, stay present, and handle your business. But some people seem to prefer the hard way, and while that's frustrating, I'll admit, it makes for compelling content. If you enjoyed this breakdown, don't forget to like and subscribe. I'd love to hear what you think. Was the judge too harsh or just right? Thanks for watching. Take care and stay smart out there.